Hi, my name is Paul Zarefsky, and I'm a Deputy City Attorney here in San Francisco. And for the next hour or so, we'll be discussing open government laws. It's a very important subject because open government is essential to meaningful self-government. So as you go about your city business working for a particular department, board, commission, whatever your city function may be, it's important that you execute that function in a manner that's consistent with the open government principles we'll be discussing. We'll be covering three main laws, two state laws, the State Open Meetings Act, called the Brown Act, the State Public Records Act, and our local Sunshine Ordinance, which in certain respects provides greater access to both meetings and records than is required under state law. Now, we can't cover all laws that pertain to open government. We can't even cover all facets of the three laws I've mentioned. And in the real world, when legal questions arise, often they're very fact-specific, where you need to contact your deputy city attorney, and in some cases can look to our Good Government Guide on the city attorney's website. But having mentioned those caveats, we think that over this course of an hour, we'll be able to cover very basic principles that will be instructive in many respects. We'll first cover open meetings, and there are 5 topics we'll cover. One, notice of meetings. Number 2, rights of the public at meetings. Number 3, the concept of meeting, which is just so central to open government laws. Number 4, passive meeting bodies. And number 5, closed sessions. We first address notice of meetings. And the idea is that each meeting has to have an agenda that needs to be posted at least 72 hours before the meeting, whether it's a regular meeting or a special meeting. Where must it be posted? It must be posted at the library, and it must be posted on the departmental website or the board or commission website. In addition, we recommend that it be posted at the department office or at the meeting room where the meeting will be held. Now, our recommendation is that while there's that 72-hour time limit, don't wait to the last minute, because things can happen, and if they do, you can get into a box where you don't really want to be a commission chair and get a call which says, oh gee, it was only 68 hours before the meeting where we posted the agenda. So as a practical matter, you may want administratively to get things in order before the 72 hours. What does the 72-hour deadline mean in terms of amending an agenda item? Well, if you're well in advance of the 72 hours, you can amend the agenda as you want, and you should indicate what the amendment is. If you're after the 72 hours, you can amend it if what you're doing is essentially providing greater specificity or something along those lines, but not really going beyond what the original agenda item said. On the other hand, if you're really changing it, then you've got a problem because you haven't met the 72-hour deadline. The law is a little unclear if you're at 71 and a half hours. Does the law require absolute compliance versus substantial compliance? Let's not get into that bind. Let's be sure that we meet the 72-hour requirement. Now, what does an agenda item need to do? It needs to be sufficiently clear and specific to alert a person of average intelligence and education whose interests are affected of reason to attend the meeting or seek more information on the item. In other words, it's sort of a reasonable person standard. You need to put enough in the agenda item where a reasonable person who's interested in the subject matter would know, hey, this is something I'm interested in, and maybe I'll attend the meeting or seek more information about it. You need to specify for each agenda item whether it's a discussion item, an action item, or if it's not going to be really clear in advance which it is, you can say discussion and possible action. And the agenda also has to refer to explanatory documents. Now, these are examples of what I call questionable descriptions. You have an ordinance, for example, that deals with real estate, and it may have the technical legal description, but it doesn't have the street address. And so that's not going to be very meaningful to the public in terms of what property is involved. You have a contract that's going to be discussed or acted upon, and maybe you name the contractor, but you don't say the amount of the contract or the purpose of the contract. Maybe the agenda item refers to a particular piece of legislation, and you just put the bill number, but you don't say what the subject is. Or you have these general descriptions like new business or director's report. All of these things are questionable descriptions because they don't tell the public enough about really what will be covered in the meeting. Now, why is all of this important? It's important for the reason here. A policy body, which is the fancy legal term for a board or commission, can't discuss or act on items that are not on the agenda. The agenda is the roadmap to the meeting, and you can't go off the road and have some jaunt somewhere else that's not on the agenda. Now, there are a few exceptions to that, but these are very, very limited, and I almost hesitate to even mention them in this presentation, lest people get the impression that it's easy to just go off the agenda. But there are certain exceptions for public health or safety, emergency, immediate need to avoid serious injury to the public interest, and a more technical one if the item has been on a previous agenda and it's continued to a next meeting, and the next meeting is no more than 5 days later. But I think it's important to emphasize again, don't rely on these exceptions except in rare circumstances. You really have to stick with what is on the agenda. Now, there are certain things that really don't rise to the level of being agenda items and therefore are not subject to the rules I've just covered. Announcements, where you're not really discussing something, you're just presenting some basic information about, oh, I attended such and such meeting last week. A request by a member of the commission to agendize items for the future. Direction to staff to follow up on something. And when there's general public comment, which we'll cover in a little bit, there can be limited follow-up questions for purposes of clarification, but there can't be any real discussion. There are certain form notices that have to be on agendas. Date, time, place of meeting, disability access, sunshine rights, in other words, informing the public of their sunshine rights and where they can complain if there's a problem they perceive, where agenda materials are to be located, agenda materials accompanying the agenda items, and materials that are developed after the agenda has been posted, because while the 72-hour requirement for posting the agenda is a very straightforward and strict requirement, it doesn't mean that accompanying agenda materials have to be ready in that 72-hour period. And there are other notices relating to the ringing and use of cell phones, chemical sensitivity, and boards and commissions can put other notices on there that they wish, like transit routes to get to the site of the meeting and so on. So that's our basic summary about agendas, agenda items, how to deal with them. We now move to our second main topic, which is rights of the public at these meetings. And there are 4 basic rights: the right to attend, the right to record, the right to comment, and the right to receive agenda materials. With respect to the right to attend, this is probably the most basic right the public has with respect to meetings of boards and commissions. The idea that they're open to the public. We talk about open government, and if the public can't attend these meetings, then how could we really have open government? So there has to be non-discriminatory admission, there has to be disability access, there can't be any preconditions like you have to sign up in advance or anything like that. You can't charge a fee for attending one of these public meetings, and you can't require people to sign a sign-in sheet. You can have a sign-in sheet if you want it for purposes of further contact with people who are interested in the subject matter of the meeting. But it's important, if you do that, that the sign-in sheet prominently says that it's optional for people to sign in. People have a right to attend these meetings without any sort of preconditions. The right to record is the second important right. And the idea here is that whether it's a photograph, a video, audio, people have a right, just as they have a right to attend, they have a right to, in effect, preserve what is going on, and they have a right to broadcast it as well. And these rights of recording, if you will, can be curbed only if the policy body makes a reasonable finding of persistent disruption that would occur if this recording was to happen. It's an extremely high standard. It's going to be virtually impossible in most cases to meet. Now, there's no obligation on the part of the city to provide recording equipment to people, but there is an obligation, if they have their own recording equipment, to work reasonably with the member of the public so that they're able to record. The next right, which is important, and this is one that I think many of us are quite familiar with if you've served on a board or commission for any period of time, and that's the right of public comment. And there are 2 types of public comment. There's general public comment, and the idea there is the public has a right to comment on any item within the subject matter jurisdiction of the body. And that can happen at any time in the meeting. And when I say that can happen at any time in the meeting, what I mean is that the policy body has discretion. If they want to schedule general public comment at the beginning of the meeting, they can. At the end of the meeting, they can. The middle of the meeting, if they want. I know some bodies which have sort of had a hybrid procedure where you have it at the beginning of the meeting for 30 minutes, and then if there's a need for more, you have the remainder at the end of the meeting. So the timing is flexible, but the requirement is not flexible. There always has to be general public comment at a regular meeting. Now, the other type of comment is comment on a specific agenda item. And it's important that if action is to be taken on that agenda item, that the comment occurs before the action is taken. Because obviously, if it occurs afterward, it sort of becomes less meaningful. If you don't have an action item, it's just a discussion item, then the comment simply has to occur before the policy body has concluded its consideration of the item. A few comments with respect to general public comment. It needs to be agendized on the agenda so that people know that there is that period for general public comment. As I mentioned earlier, members of the body are not supposed to discuss the general public comment or respond substantively. There can be limited follow-up questions for clarification and so on, but there can't be discussion. And the reason is what we've already mentioned, and that is that if you start to get into discussion, you're now in a situation where this should have been specifically agendized as an agenda item so the public would know what is going to be discussed. So it's very important with general public comment that members of the policy body not then engage in an extended discussion of it. And as far as general public comment is concerned, as I mentioned, it's absolutely required at regular meetings. It is not required at special meetings of a body, although the body has discretion if they wish to allow general public comment at a special meeting. Special meeting, incidentally, is one which is not at the same time or place as a regular meeting, and typically what happens at special meetings is there's one topic or two topics that the body is focusing in on. So for a special meeting, general public comment is optional. Rights of the speaker. In other words, what does this right of comment really mean? Well, one key component of the rights of the speaker is the concept of equal speaking time for members of the public. It's very important that policy bodies not favor one side or the other in terms of members of the public commenting on things. It's very important that you not give 3 minutes to the first 5 or 6 speakers and then you realize, we've got so many speakers here, we need to cut down and we'll now do 2 minutes. You can't do that. There has to be equal speaking time for members of the public. Now, if you're not a member of the public, you can go longer than that. For example, the policy body, let's say, retains some outside expert to speak on a particular topic. Well, for purposes of that agenda item, that person's not really a member of the public. There's someone that the policy body has scheduled as part of the program. Similarly, staff members or representatives of governmental agencies are not considered members of the public for this purpose. In terms of calculating speaker time, it's important that if a speaker is interrupted during their speaking time, where there's a question from the commission or something along those lines, that the question and the answer to the question is not considered as part of the speaker's time. And if you have a situation where someone is not an English speaker and they brought a translator in, you're supposed to give double time in that situation. Another important component of the right of public comment is the idea that you can comment anonymously. It's common for boards and commissions to ask people to state their names, but if you do that, it's very important that it be clear that it's optional. You can't require that. People have a right to speak anonymously. And of course, the final point to emphasize is something that may be obvious, but maybe not, and that is, in terms of the content of public comment, members of the public are free to criticize the policy body, its members, departmental staff, to criticize the policies and so forth that the policy body is adopting. You know, it's a very broad range of public comment that's allowed. There are, though, some limits on public comment. The law says that a speaker has a right speaking up to 3 minutes on an item. That phrase has been interpreted by the courts to actually mean it can be less than 3 minutes provided there's a reasonable basis for it. if you have a whole lot of speakers on an item, if you have a whole lot of agenda items to consider, if there's limited time at the meeting, and those sorts of practical considerations can justify going less than 3 minutes. But it's important, if you do go less than 3 minutes, that you made a judgment that the amount of time allocated for each speaker is such that there still is a meaningful right of public comment for that speaker. There's no right to speak off topic. You know, when you've got a specific agenda item, a chair has the discretion to tell the speaker that they're off topic. And what chairs should do actually is use some judgment in that regard. Maybe if it's close, sometimes it may not be worth it to sort of get the speaker off track, but it's really a judgment that the chair needs to make under the particular circumstances. There's no right that a speaker or anyone else in a meeting has to disrupt the meeting, but at the same time, disruption is not the same thing as the speaker saying something that upsets members of the policy body. If you don't have a thick hide, you really shouldn't be on one of these policy bodies, because in public comment, there's the right of the public to criticize, to sometimes even be obnoxious, if you will, and it's not something that, by its own terms, is disruptive. There's no right that a speaker has to a response, and oftentimes it's a good practice to not really respond to people who speak during public comment, but there's certainly no right that anyone has to it. And the final right of the public, we've talked about the right to attend, we've talked about the right to broadcast, we've talked about the right to public comment. The final right is the right to agenda materials, and there's a sort of a detailed structure of when you can get agenda materials. If they're intended for distribution before the meeting, you have a right to inspect and copy them before the meeting. If they're distributed during the meeting but before an item is heard, the public has a right to inspect those materials. If possible, the material should be copied before the item is heard. And if you have materials that are distributed during the meeting when the item is heard, it really depends on the source of the materials. If the source of the materials is the department, the policy body, well, they should have copies already ready for distribution, but you can't expect that necessarily if the materials are provided by a member of the public. Before we go further, just a checklist, if you will, for commission chairs with respect to these sorts of issues. Because of the importance of public comments, it's important that the chair remember for each particular item to ask for public comment on that item. Even if the chamber is bare and there's no one there, you still want the record to show that you've asked for public comment and there's none. It's required that when there's a vote on an item, you have to announce the specifics of the vote after that item. If it's unanimous, fine. If it's not unanimous, you need to say, oh, it was a 4-3 decision with commissioners X, Y, and Z in the minority. So it has to be a very specific announcement. It is possible on the part of the chair to rearrange the sequence of items. I mentioned that the agenda is a roadmap. You can't go off the road, but you can sort of change your route so long as you're on that same road. So you can move items up or move items down, but if you do, the law requires that as soon as you know you're going to do that, you need to announce it to the members of the public who are in attendance at the meeting. On the other hand, if an item has been scheduled for a specific time, at 2:30 we're going to have this particular item, then obviously you can't take it earlier than that because you've given notice to the public that it's going to be at 2:30. And one point which I've sort of already mentioned but maybe bears emphasis, it's important that chairs not eject speakers because they're abusive or obnoxious or say bad things or anything of that sort. It's a very high standard before there's anything that would allow a chair to do that. Now, it's different if a speaker is just going on and on past the allotted time. It's important for a chair to enforce that time requirement, because if the chair doesn't do that, then you run up against violating the equal time principle that we discussed. But in general, you can't just eject speakers or anything like that because you don't like what they're saying. The next topic with respect to open meetings that we'll cover is discussing the whole concept of what a meeting is. And the reason this is important is that almost all of these principles we discuss, all of these rights people have, all of these requirements of agendas and so forth, they're all keyed to there being a meeting. If you don't have a meeting, then those rules just don't apply. So it's an absolutely critical concept for us to emphasize. And the key point about having a meeting is that it's a majority of the members of the policy body. If you have a policy body that has 7 seats, you have a meeting. If you have a policy body that has 7 seats, you have a meeting if 4 members are present. And it doesn't matter if, let's say, the 7th seat is vacant, or let's say somebody's ill or anything like that. That doesn't matter. What matters is the number of seats on the body. If you have a majority of that, then that's determinative. The people being together at the same time and place, or the members of the body, a majority, communicating in some other way, is a meeting. The subject matter of the discussion, the state law says that if they're getting together a majority and they're discussing something within the subject matter of the jurisdiction of the body, the Sunshine Ordinance doesn't have that last language in there, and literally read, it just means whenever a majority of the policy body is together. We encourage a situation of a majority of the policy body not getting together and discussing anything relating to city business, period. Now, what are legal meetings? Well, the first thing here, everyone will recognize the formal meeting of the body. You know, you have a room in City Hall or wherever it may be, and you go through a meeting with motions and adoption of things and so forth. But there are other types of meetings that are legal if they're done properly. For example, policy body may want to have a retreat, and they can do that, but it has to still follow the basic rules. There has to be an agenda, and there has to be a right of the public to attend and comment and so forth. Similarly, the policy body can go on a site tour if there's particular property they need to inspect or something along those lines. But again, it has to be done in a way that complies with the agenda requirements, right of public comment, etc. And the Sunshine Ordinance provides that meal gatherings before, during, or after a formal meeting are considered part of the meeting, with the idea that the public can attend and observe. Now, what are illegal meetings? I've designated these 2 categories, pre-meetings and post-meetings. What I mean by that is, let's say you're a policy body and your meeting starts at 6 p.m. You can't have the members of the body get together at 5 p.m. and sort of go through a dress rehearsal of the meeting itself. That's something that could be done maybe in the private sector and might even make a certain degree of sense in terms of having a more structured, more organized meeting, but you can't do that because, you know, the public's not part of that. Same thing post-meeting. If you've had a 3-hour meeting and then majority of the body stays after and they sort of recount what happened and go into detail about it and so forth, they shouldn't be doing that. Teleconferencing, this is something that is recognized in the Brown Act as a way in which meetings can occur, but our local law, particularly our charter, generally does not allow teleconferencing. And then finally, the most notorious, if you will, kind of illegal meeting is what's called a seriatim meeting, which is sort of Latin for a serial meeting. And this can occur in a lot of different ways. You have Commissioner A talks to Commissioner B about a particular subject, and then B talks to C, C talks to D, and all of a sudden, 4 of the members of your 7-member body have had a meeting. I mean, they haven't done it all together at the same time, but in substance, they've had a meeting. Or you can have one member, A, talk to B, and then A talks to C, and then A talks to D, and all of a sudden, again, you have these 4 members of the 7-member body that have been involved in substantive discussions of a particular topic. Or you can have some combination of the above, or you can have a joint communication. If you just have a one-way contact, if one member of the 7-member body sends something out, technically that's not a violation, but we still very much discourage that because as a practical matter, it can lead to subsequent discussion where it's no longer a one-sided communication or a one-way communication. Now, serial meetings or seriatim meetings can occur just in person. It can occur through email, text message, phone call, fax. It can occur through the use of human intermediaries, so that if an aide, for example, to Commissioner A is talking to an aide to Commissioner B, talks to an aide to Commissioner C, and an aide to Commissioner D, and so forth, it's still an unlawful serial meeting, even though the commissioner himself or herself was not involved. Their intermediary was. Now, what are non-meetings? There are certain circumstances where the law recognizes even if a majority is present together, it's still not considered a meeting and hence not unlawful. One situation is where a non-member of the body, in other words, let's say a member of the public, communicates with a majority of the members. If it's done in the context of one-on-one communication, Joe Dokes from the public talks to Commissioner A and then has a separate meeting with Commissioner B. And in those situations, the views of other commissioners are not mentioned. That situation then is okay. If you have an attendance of a majority of the body at a regional or larger conference or at a local meeting, if it's not organized by the city, those are not considered meetings under the law, provided they're open to the public and there's no collective discussion among a majority of the members of the body, of the business of the body. You can have a social or ceremonial event not sponsored by or for the body, like a wedding, a funeral, things of that sort, provided it's purely social ceremonial, it's not sponsored by or for the body, and there's no collective discussion of business. You can have a majority attend as observers at a meeting of the standing committee of that body. You have a 3-member committee of a 7-member body, and a 4th person who's not on the 3-person committee wants to attend, they can do so as an observer. These situations can get kind of tricky. They can be very fact-specific, and they're very sensitive. Make sure you don't cross the line. So in these kind of situations where it's possible a majority can be present, we recommend to check with our office about those situations. How are policy bodies created, which is another way of saying what is a policy body? It's a multi-member body which is created by charter, ordinance, resolution, other formal action or initiative of the policy body, or a grant if city officials or employees appoint members to the body. And this is a very important slide because what it emphasizes is that policy bodies can be created by policy bodies. For example, you have a commission that has 7 members, and when they create a committee of 3 or whatever it is, that too is a policy body that has to abide by the rules governing open government. It doesn't matter what the membership of the committee is. It might be all members of the parent body. It might be all members of the general public. It might be a mixture. It doesn't really matter. So long as it's a committee created by the parent body, it's a policy body itself. It doesn't matter the nature or the purpose of the committee, whether it's a standing committee or ad hoc. So long as it's created by the parent body, it's going to be a policy body. This can occur in more subtle ways. Let's say you're at a commission meeting and discussing an issue, and it's decided, well, we need to look into this further, so let's have Commissioners A and B look into it. And you haven't really formalized it, and you don't necessarily even take a vote, but there's sort of a consensus that the policy body needs these 2 members to look into something. Well, you may have informally created a policy body. And similarly, you might have the chair of a commission who says, well, I'd like Commissioner A and B to look into this. And again, it's not necessarily a formal vote, and it may just be something that the chair did, but the chair, if doing it on behalf of the body as a whole, may have created another policy body. What then is not a policy body? A policy body is a multi-member body. Therefore, when you have an individual who's acting, it's not a policy body. It could be one of 7 commissioners doing something. Well, that's not a policy body. It could be a hearing officer. It could be a department head. Those are not policy bodies. And so those aren't subject to the various requirements of the Brown Act and Sunshine Ordinance we've been discussing. In addition, if you have a multi-member body that's created in some way other than what I mentioned, it wouldn't necessarily be a policy body. Now, what might that be? We have in the Sunshine Ordinance an innovation that's not present in the Brown Act, and that's the concept of a passive meeting body. And the concept is that it's not something that was created by ordinance or charter, resolution, or anything of that sort, but it's a body that's been appointed by the mayor or a department head or an individual commissioner to look into something, So it's sort of like a policy body. It kind of has a similar function, but it wasn't created in the same way. And as I say, it's not recognized in the Brown Act, but it is recognized in the Sunshine Ordinance. Another example of a passive meeting body is a social, recreational, ceremonial occasion by or for a policy body, and a majority of the body is invited. A good example of that is some boards and commissions have a December holiday party or lunch or something of that sort. That would be considered a passive meeting body. And then there's certain employee committees that are created, let's say, by a department head to formulate city policies that can be considered passive meeting bodies. What's the significance of a passive meeting body? I think the best way to think of it is what we call sunshine light. It provides some degree of open government, but not the full-fledged rights and so forth that you have when sunshine fully applies. The most basic right, the thing that's most important about the passive meeting body, is the idea that it's open to the public. And so in that respect, it's similar to the full-fledged policy body. And of course, there has to be disability access because the passive meeting body is, in some sense, a body that's created under the aegis of city government. You have to provide notice on the departmental website or the commission website if feasible or if possible, and other notice if requested. For example, let's say there's a commission that has an ongoing passive meeting body that was created by a department head. Let's say it's not really a commission, it was created by a department head. And you have members of the public who are interested in the subject of that passive meeting body, and they say to the department head, hey, let me know whenever you're going to be having a meeting. Well, in that situation, there's a right of that member of the public to get that individualized notice. There's no agenda required for passive meeting bodies. If one exists, it has to be provided to a member of the public on request, but at the same time, because it's not required in the first place, you really don't have to follow it. So all of the things I emphasized about agendas and so forth that apply in the context of meetings of full-fledged policy bodies don't really apply in the context of a passive meeting body. And there's no right of public comment at the meetings of passive meeting bodies. Now, sometimes they may choose to have the public comment. There's nothing wrong with it, but there's no really right of public comment the way there is at the full-fledged policy body meetings. The key thing about passive meeting bodies is the idea of being open to the public. And the final topic I want to cover in terms of open meetings is closed sessions. This is an important but sort of narrow aspect of open government law. There are certain types of closed sessions. There's actually a whole lot of them when you go into the details of the Brown Act, but there's 4 or 5 that are the most common. Personnel matters, pending litigation, instructing a labor negotiator on the position of the city in labor negotiations, instructing the real estate negotiator of the position of the city with regard to a real estate transaction. There's a closed session provision to discuss security threats, and then, as I've alluded to, there's miscellaneous others that are very narrow and focused. Before having a closed session, there are certain requirements. There are special agenda requirements that you need to put on the agenda so that people understand this is proposed as a closed session. You can go ahead and even if it's agendized as a closed session, you could have it as an open session, but it doesn't work the other way. If you have something scheduled and it's not designated as closed session on the agenda, you can't then go into closed session. So there's special agenda format requirements. It's important that the right of public comment happen before the body goes into closed session, because once they go into closed session, hey, they're not going to be able to hear the public comment. So that needs to happen before they go into closed session. As far as deciding to go into closed session, a vote is required for the pending litigation closed session. The other types of closed sessions, technically speaking, a vote is not required, but many boards and commissions do have a vote of the members to go into closed session as a matter of their custom, practice, or bylaws. What are the important requirements during the closed session? Number one, you got to stay on topic. Remember, closed session is an exception to the rule that meetings are going to be open to the public. And so it's absolutely critical that the members of the body don't stray from what the subject of the closed session is. Now, sometimes it's hard to draw that line, but it's very important to try to adhere to that line, because if you start in closed session getting into things that really are not within the topic, or not fairly within the topic, you've got a violation of the Brown Act and the Sunshine Ordinance, and you want to stay away from that. You want to think of closed sessions as the exception rather than the rule, and because they're exception, you got to kind of stick to the straight and narrow, if you will. There's a requirement in the Sunshine Ordinance, not in the Brown Act, this is an innovation of the Sunshine Ordinance, that all closed sessions have to be recorded, and those recordings have to be maintained indefinitely. And that's an important protection, if you will, because sometimes issues will arise in subsequent litigation or whatever it may be, where it's useful to have the recording. And by way of illustration, it's a way of emphasizing that while closed sessions are closed, you can't, as a commissioner, assume that it will forever be closed or anything of that sort. And so while it's completely legitimate in many of these circumstances to go into closed session, you have to conduct yourself during the closed session as if, well, at some point in the future, maybe the discussion will be disclosed, because there is this recording that we now require. It's important that the attendance at the closed session be limited to the commissioners, be limited to staff or employees to aid the body, and any necessary participants in the session. You know, if it's a hearing on something, you know, the witnesses, for example, or the parties in the hearing. What are the requirements after closed session? The law provides that certain kinds of actions, not all actions taken in closed session, but certain kinds of actions that are specified in the Brown Act and Sunshine Ordinance have to then be disclosed to the public when you come out of closed session, go into open session. You have to, after coming out of closed session, vote in public whether to disclose any closed session discussion. And then this final point is absolutely key. You have to maintain confidentiality of closed sessions unless the body has authorized disclosure. I don't want to hear about anybody who has attended or watched this presentation. I don't want to hear about their policy body having gone into closed session and then the next day you read about the details of it in the paper. That's not something that's supposed to happen. It's a very serious violation of the responsibilities of a member of a policy body. Now that really covers our discussion of open meetings. We've tried to cover the basics. We haven't covered a number of topics. As I mentioned before, we can't cover everything. But hopefully, discussion of these 5 items that we've had here will provide a good springboard for then any consideration of these kinds of issues that will come up as you're having meetings of the policy body. We'll now move to public records, which is the other half, if you will, of our open government laws. And the public records it's just absolutely essential as far as open government is concerned. And what I've found in the nearly 20 years I've been in city government is that the public records landscape has really changed, where it's very common to receive public records requests. They can be voluminous, they can be frequent. People now understand their right to get information from their government. And so it's absolutely essential, however a department does it, that they adequately staff their processing of public records requests so that the public's rights here are vindicated. We'll cover 3 main topics with respect to public records. First, the definition. Second, the process for handling requests. And third, exemptions. The definition of a public record is extremely broad. It's any type of writing, regardless of physical form or characteristics. So you should almost forget about that word writing, because we don't mean an old-fashioned writing. We mean any kind of recording of information. You know, it could be a photograph, it could be digital, you know, whatever it is, any kind of recording. And the recording has information relating to the conduct of the public's business, prepared, owned, used, or retained by any state or local agency. So when you go through those 4 elements of the definition, you can just tell it's very broad. And there's virtually no issues with respect to the first element about, is something a writing? Almost everything is a writing. And usually there's not much issue about whether it's information relating to conduct of the public's business. Sometimes you can get into difficult issues about whether it was prepared, owned, used, or retained by the state or local agency. One issue that came up recently, actually it was festering for a number of years and then was finally decided by the California Supreme Court, is what do you do about public records that are on someone's private electronic device like their phone or their personal computer? And what the Supreme Court said in a unanimous decision is that if you have something that otherwise would be a public record if it were on a city computer or a city phone, it remains being a public record even if it's on a private electronic device. In other words, if the message meets the definition, the medium doesn't matter. And so in these situations where we get a public records request and it's important for the employee to search through their phone and see what they may have on there in the way of a text message, or search through their own personal computer and see what kind of personal email they have, you consider the substance of the message, its purpose, context, sender, recipient, to decide, hey, is this a public record or is this just a text message to my spouse saying I'm going to be late for dinner because there's a lot of work to do today, which would not be considered a public record. The responsibility for the search, at least initially, resides with the employee or the official who has the phone or the personal computer, whatever it is, but ultimately it is the responsibility of the department to respond to the public records request and be satisfied that there has been an adequate search. We have said that because this now is an integral aspect of public records law, the concept that people using their personal electronic devices may still be involved with public records, that the public records request does not have to specifically ask for a search of personal electronic devices, but rather it's up to the department to make clear that employees with relevant information have to do the search. And just an aside, going back to our discussion of boards and commissions, one thing to be concerned about or to be aware of is, to the extent you're texting or emailing or doing things like that during a meeting itself, if there's a public records request for those things happening during meetings, it's going to be difficult to withhold those sorts of records. It can be, kind of a sensitive situation. So beware of that and maybe consider not texting or emailing during meetings. Now, the definition, as I say, of public records is very broad, and there are a few interesting issues that come up there, but the most important thing to get out of this presentation with respect to public records is this next topic, the idea of the process for handling public records, that everybody understand what their responsibilities are in processing these. And first, let's get an understanding of the request itself, what the requirements are. And the requirements are very bare. It's important that the request specify the record or category of records, but this is not a strict requirement. You don't have to have the request say, well, I want such and such memo from such and such person to such and such person on such and such date. No, not at all. Just so long as the receiving department can understand the substance of what it is that the person is requesting, that's a valid public records request. Public records requests can be oral. Some people don't recognize that because we're used to them being written. Certainly written is better, and if someone makes an oral request, it's important for the department to sort of reduce it to writing so you memorialize it so there isn't confusion. But the point is, a request can come in all sorts of forms, including oral. And of course written, it could be email, it could be an old-fashioned letter, whatever. Public record requests can be anonymous. There, of course, has to be a way in which the department is able to communicate with the requester, but it may be anonymous. There's no requirement of having magic words. You don't have to say, this is a public records request, this is a sunshine request, or under the Public Records Act, or anything like that. Again, it's just a matter of, does the department realize that a request has been made for records? And this final point is a very important one. There's no justification requirement. The requester doesn't have to say, well, I want such and such record for such and such reason. They have a right to the record, and they don't have to justify it. Types of requests: you can either request to inspect a record or request copies of a record. and it's really up to the requester. It's their choice, and sometimes they may even do both. They first come in and they inspect a series of records, and then they tab those that they want, and they get copies of those. And so the point here is that this is really up to the requester how they want access to the record. Time for response. There are two types of requests. The first is an immediate disclosure request, and again, this is an innovation of the Sunshine Ordinance. This is not something in state law. But the idea is that somebody makes an immediate disclosure request for a single document or small number of documents that are easily located. And it's just a simple routine type request that can easily be satisfied. Has to be satisfied by the end of the next business day. There then is the standard public records request, and you have 10 calendar days to respond. And then for both of these, there's the ability to extend for up to 14 calendar days. There also, under the Sunshine Ordinance, is an innovation called a request for description of records. It's not a public records request, but it's a request of a department that the department summarize the kinds of records it has, and the form in which they're held, and things of that sort. So that's sort of the landscape of the types of public records requests. And the moral of the story here is that it's very important when a department gets a public records request to start working on processing the request right away, because time is of the essence. These time deadlines are strict. There's a lot of other things a department has to do, and so you have to juggle all of that, but you don't want to put the public records request on the back burner, because you can get burned if you do. Now, as I mentioned, there are situations where you can extend time. You can't just do it for any old reason. You can't do it because, oh, we got a heavy workload or something else, or somebody's on their vacation. Those are not really valid reasons. There are 4 reasons. Number one, that the records requested are voluminous. Sort of an imprecise standard, but you apply it on a case-by-case basis. If records are off-site, if there's a need to consult with another department, this comes up frequently, whether it be consultation with our department, the city attorney's office, or within city government. If the police department needs to consult with fire and needs to consult with DEM or whatever it may be, it happens frequently, and I think increasingly frequently, because of the complexity and the frequency of public records requests. And finally, electronic data that must be compiled. In other words, you have the information that the requester has sought in an electronic form, but you don't quite have it organized the way the requester has sought, or in the categories. And you need to kind of reorganize it electronically. In that situation, you can get an extension. There are some nuances about these time requirements. You're supposed to, once you get into the extension world, provide the records without unreasonable delay. So sometimes you're not going to really know how long it's going to take, and so you can say, well, we'll get it to you no later than, and then you put the 14-day date in there. But the reality is you need to make a good faith effort, if you can, to get it to the requester before the 14 days are up. There's an obligation to produce records on a rolling basis. This is important because if you ever get into a controversy, whether it be internally or there's actually a litigation filed or anything like that, it's very important for the department to be able to show that it acted in good faith and took seriously and conscientiously its responsibility to provide records. And oftentimes with huge requests, you can't provide everything all at once, but you can provide some things earlier than others, and if so, you should do so. And one final point, I mentioned the immediate disclosure request process that we have under city law. It's important to emphasize that while an immediate disclosure request has to be identified as such, identifying as such doesn't automatically make it so. If you have an immediate disclosure request, so-called, that's asking for documents in 100 different categories or something of that sort, I mean, just on its face, it's not an immediate disclosure request, even if the requester has so labeled it. Now, under both state and city law, there is a duty on the part of the department to assist the requester. And this is an important point to emphasize because public records is different from litigation. You get in a litigation context and sometimes it's sort of hard-nosed fight between the city and whoever the other litigant is. In the public records context, the notion is that it's almost a cooperative process, that if there's a problem with the request being unclear, that the department should try to assist the requester in clarifying it. If the request is too open-ended, assist the requester in narrowing it. If the requester is sort of unclear about what types of records to request and what may exist, let them know. And if there's records that another department has, to direct the requester to that department. Say, hey, we don't have anything, or here's what we have, but you may want to also contact Department B and Department C because they may have responsive records as well. There's a duty to conduct a reasonable search. Now, this is a matter of degree. You don't have to seek a needle in the haystack. What it means is you need to consult the people and the files that are relevant to the subject matter of the request. It also means you need to keep your records in orderly files so that you can facilitate any search. And as I've mentioned already, there is a responsibility to search personal electronic devices. There's no duty to respond to written questions, although that may, in some circumstances, be a good practice. It may, in other circumstances, not be a good practice, but it's not, strictly speaking, a legal requirement. There's no legal requirement to create a record that doesn't exist. However, that's sort of an old-fashioned notion. That's true with respect to the old-fashioned hard copy document. But as I've already mentioned, if you have electronic information that's stored in a certain way and you need to rearrange it, there is a responsibility to do that in many circumstances. There's no duty to create a privileged log to list the things that you're not providing. What's the nature of response? Response should be written. You either say we have no responsive records or we have responsive records, and for responsive records, you disclose them. Don't disclose them, disclose some, but not based on exemptions. And then within a record, you may redact certain things based on exemptions. If you withhold a record in full or part, you have to state the legal justification. You have to explain the process for the requester to inspect and or copy records, state the copying fees, if any. The fees here, we'll just go over this very quickly because realistically there's not much in the way of fees required. 1 cent for a document routinely reproduced, 10 cents for other records. More if it's an itemized kind of thing, a document that's a strange shape or something of that sort. If it's a tape or some other medium, the cost of the medium. And for videos of meetings, no more than $10. You may not charge for the things that really cost a lot, the search for, the collection of records, the time taken redacting records, the overseeing of inspection of records, time to copy records, preparing response, all of those things which are the bulk of the time required, you can't charge for. And the final important topic with respect to public records is exemptions. And the idea here is that you are allowed to withhold a document or redact a document based on legal exemptions, but the Sunshine Ordinance prohibits relying on general balancing and saying, oh, on balance, the public interest in non-disclosure outweighs the public interest in disclosure. Can't do that anymore in San Francisco, given the Sunshine Ordinance. It has to be specific exemptions you're relying on. You can't rely in San Francisco on the deliberative process privilege, which is something commonly used in other jurisdictions. And there are detailed rules we don't get into here about withholding of certain contract-related documents prior to award of the contract. But many exemptions still exist, and we just list them here. We can't go into any depth on them, but some of the more common ones for private information, including personal contact information, personnel records. There are special rules governing personnel records for peace officers, medical records, all of these things that relate to privacy. And then trade secrets, which is sort of the privacy equivalent for businesses. But all I'll say for now is that the rules regarding trade secrets are complicated, and definitely check with our office when trade secret issues come up. There are certain protections for informants, complainants, whistleblowers, protections obviously for attorney-client communications, attorney-work product, and just a whole host of other exemptions out there. Library circulation records, real estate appraisals, employment test questions, law enforcement investigative and security records. Now, certain pointers to emphasize in the context of exemption: there's no such thing as an embarrassment exemption. You may not want to disclose a public record because it'll be embarrassing. You know, that just goes with the territory. There are a large number of exemptions out there in state law. Some of them are obscure, some of them are well known, but they may be adapted in new circumstances. And what I always advise departments in the public records context is go with sort of a gut check. If you have a concern, a legitimate concern, not an embarrassment concern, a legitimate concern in terms of the operation of a program with disclosure, again, check with our office, and there may well be a legal exemption that sort of parallels the concern that you're raising. It's important to note there's a difference between mandatory and discretionary exemptions. Mandatory exemptions, you have to invoke it. You know, certain privacy things, you cannot disclose someone's Social Security number. That's a mandatory exemption. And then there are discretionary exemptions, which are up to the department to choose or not choose to use. The final point with respect to exemptions is critically important, and that is the idea of waiver. What the law says is you can't give a record to person A, requester A, and then requester B comes along and you deny the record to requester B. So there's that sort of notion that you've waived any right to withhold the record, even if initially you had that right. Because of this, departments necessarily have to be careful in what they disclose. And you'll hear this general principle, which is true, that our laws favor disclosure, and in close cases, well, that's how it goes. But in reality, because of the waiver issue, you have to be careful about disclosing something, because once you've disclosed it, you've waived the ability to withhold it in the future. There are some exceptions where this waiver principle doesn't apply, like providing information under certain circumstances to other governmental agencies. So that's public records. I want to just very briefly talk about enforcement. My whole premise here is that every person watching this video is going to want to conscientiously adhere to these principles. But just in case there's anyone out there who has a notion of sort of skirting the rules or anything, you need to know that with respect to the Brown Act, and here we're talking about boards and commissions, there actually is a criminal sanction if there's a willful violation, an action taken in violation of the Act, with the Brown Act, with intent to deprive public of information to which it's entitled. Now, I don't want to scare people. This is rarely invoked, but at the same time, you need to know that this is out there. And so you have to take seriously this notion of making meetings open to the public and so forth. In addition, as I've already mentioned, unauthorized disclosure of closed session discussion is very serious and can lead to removal from office. Additional remedies, people can go to court to void certain actions taken in violation of some provisions of the Brown Act. Injunction or declaratory relief can be sought to stop or prevent violations of the Act, and attorney's fees and costs are available. For the Public Records Act, the key sanction is declaratory and injunctive relief ordering disclosure of a record. In other words, the agency has not provided the record. You go to court, court says you have to get it, have to give it to the person. And the key thing here is the city gets hit with major attorney's fees and costs, because those mount up very quickly. And both from a fiscal standpoint as well as an open government standpoint, it's important, therefore, that people adhere to the requirements of the Public Records Act. We have within city government another innovation of the Sunshine Ordinance, and that's the Sunshine Ordinance Task Force, which has broad jurisdiction to hear open government matters. It gives the members of the public the opportunity for an inexpensive, informal hearing to resolve their disputes with the public agency. And the task force can make findings of violations and request cures, and if cures are not provided, can refer matters to the Ethics Commission under certain circumstances. And that's it, really. We've tried to cover the basics. I would encourage everyone, as issues arise, to consult our office, the particular deputy city attorney who advises your board or commission or department. And also, as I've mentioned, on our city attorney website, we have a good government guide which goes into greater depth as to many of the topics we've covered here and some topics we haven't. So with that, I'll bid you adieu, and I'll encourage everyone once again to take these requirements seriously, because open government is so essential to healthy self-government, which is, of course, something that all of us value. Thank you.